Welcome back to What I Missed. Let's talk a little about one of the witnesses in the YSL trial by the name of Kenneth Copeland, aka Woody. Now, on June 7th, 2024, Kenneth Copeland, aka Woody, took the stand and was sworn in. A few moments into his testimony, Kenneth Copeland pleaded the Fifth. Chief Judge Earl Glanville immediately dismissed the jury and held Kenneth Copeland in willful contempt and stated, "We are going to see by Monday if he could give some more testimony at that point of time."
Affirmative testimony to everybody give report of the truth, the whole truth, nothing but the truth, help.
Yes.
You may be seated. Can you state your first and last name with the spelling of both, please?
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
KennethCopeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the Fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, for sure.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Now pay attention to his body language when he said he will see him on Monday. His posture and facial expression says it all, but I will let you be the judge of that.
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Now let's rewind to a few hours before Kenneth Copeland took the stand. Now here's when it gets messy. On Friday, before Kenneth Copeland took the stand, Prosecutor Simone Hilton said Copeland's attorney, John Melnick, requested prosecutors to cease all communications with his client.
All right, Deputy Avila, all our jurors present, madam?
Yes, Judge.
All right. Before I call for our jurors, any issues I need to take up?
Yes, Your Honor. The state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email. Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client.
However, his client is?
Mr. Kenneth Copeland.
Okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not, but that he had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case so that anything that he testifies to in this particular proceeding would not ever be used against him. Your Honor has signed that order, and so we are ready to move forward. However, I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present in the building. I believe wanted to either address the court, but
okay, well, if he's inserted himself in that particular respect, he needs to probably be here. So can we send somebody up to Judge Krause's to inquire? Because, or is he here? Or is he outside?
I have not seen him yet. So
is Mr. Copeland or his counsel present?
Mr. Copeland is present in the courthouse. Yes.
All right. Where's Mr.
Judge, I saw Mr. Melnick this morning. I think he's in Judge Carnes.
Oh, maybe it's Carnes.
Okay. Could we see if we could find him, please, and have him tell him that we're about to call his client? Mr. Melnick is with us now, and that Mr. Copeland is outside, correct?
He's in. No, he's in.
Okay. Say again?
He's here.
Okay. All right. All right. Mr. Melnick, good morning, sir. Welcome.
Good morning, Your Honor.
All right. Sir, do you have any issues of concern or that I need to take up before the state calls your client?
I do, Your Honor.
Okay. Go ahead.
May I approach?
You may.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning, that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition, and the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter, and he asked me whether or not Mr. Copeland intended to cooperate with the state, and what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker, and we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
All right. And Mr. Malik, you are correct. I did go ahead and sign this morning. I'll make a part of the record, the court's order giving him use immunity. Okay?
Good morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Gary. I would believe that.
What does that have to do? Let's cut to the chase. Okay.
So
I mean, all of that. It may be maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right. So I'll let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Gary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, we have not spoken to Mr. Copeland.
Now, here's when it gets messy. As we now know, there was a secret ex parte meeting that took place that Monday prior to him taking the stand. Young thug lawyer Brian Steele heard about the meeting and called Judge Ural Glanville out on it, and Chief Judge Ural Glanville was upset. When Steele refused to disclose his source, Glanville held him in contempt.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get
No.
anybody else
I'm
into
asking you,
any-
how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have his. I have problems right now. and
Okay,
I'd like to
I know.
consider-
Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me,
Copeland.
tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who that. Tell me who this information was
from. I don't
come
want to be
from.
held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what. I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
We later found out what happened in that meeting when the judge released the supposed unredacted transcripts. If you asked me, he had no choice but to testify. The state forced use of immunity on him. I believe he took the stand due to duress and really never gave him an option. If you want to hear more about this situation, check out my last video. I went more in depth. I can't believe the judge tried to persuade Kenneth Copeland to not plead the Fifth, even with his attorney, telling the judge that he spoke with his client and advised him of the consequences that could take place if he chose to do so. The judge kinda intimidated him by telling him his rights again and telling him about his consequences in a demanding way. So when he took the stand and pleaded the Fifth, everybody acted like they had no idea that he was going to do that. That's corruption at its finest.
So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand.
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Coming up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I?
Yes,
I need 2 copies of it. Actually, 3.
Your sign.
Not yet, sir. Okay. Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here, and if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. State has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the Fifth.
Okay, you're taking the Fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney, I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways. Like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you'll tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. I will formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick?
Testimony should get reported the truth, the whole truth, nothing but the truth, sir.
Yes.
You may be seated. You state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor. Pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
So, please.
Spell it, please.
KennethCopeland.
All right. Thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here?
Okay. Well, are you going to let me ask you some questions?
Okay.
How old are you?
Grown?
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, for sure.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Now, Young Thug lawyer Brian Steele and a few other of his co-defendants. Lawyers argued the fact that the prosecutors knew that Kenneth Copeland was going to take the stand and plead the Fifth, which was true.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but it'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. The last thing the court knew, and he has counsel.
if a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So.
the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's the killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial. Okay.
All right, sir. Thank you.
Now, one of the prosecutors by the name of Adrian Love alleged that everything was staged.
Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So, could you sit down at that time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down and I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any
Mr.
point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
No. As what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized. It has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interests he's representing. And so we would ask that, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interests of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are. Because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch. Because now he's been told he's going to be hammered by his attorney, I guess. He told him that, I guess the state's going to hammer him. I don't even know what. But Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to a mistrial as a result of this action on the part of Mr. Copeland is a farce. Under these circumstances, we'd ask that the court deny the motion.
All right.
Judge, I would like to hear.
Yes, sir. What is it you'd like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." Mm-hmm. The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you, I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that as you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland.
Your Honor.
About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
when did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client is going to plead the Fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But, whether or not,
And answer around is my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
no, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay?
Of course.
And that sometimes has to be explained to witnesses and clients. Okay? All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So, we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to, ask that the court, convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
All right. Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you are not his counsel, and now you have put us in a situation where now you put yourself in between a rock and a hard place. I mean, so He's coming back on Monday.
I'll have somebody else make my announcement for me.
Then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll have somebody go on Monday.
And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion.
So let's fast forward a little bit more. After multiple motions were filed to recuse Chief Judge Ural Glanville, he denied every motion. Attorneys Doug Weinstein and Katie Hingerty filed a motion to the Supreme Court, even though the Supreme Court didn't grant the motion to have another judge oversee the ex parte meeting. They did state that there should be another judge to supersede the case. A person cannot be a judge and a witness in a case. Chief Judge Ural Glanville finally had a change of heart and is going to release the unredacted statements.
As you all are made aware of, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as Courts 2. So the transcript will be Court 1. His immunity agreement, Mr. Copeland's, will be Court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt.
Now let's fast forward to that following morning when Kenneth Copeland agreed to take the stand. Towards the end of that trial day, after the judge dismisses the jury, Prosecutor Simone Hilton walked up to Kenneth Copeland and started to have a conversation with him. Now you couldn't hear the conversation at first due to the microphone being muted, but somehow Kenneth Copeland's microphone became unmuted, and you heard Kenneth Copeland threaten to plead the Fifth again.
We'll be in recess 10 minutes.
I might take the Fifth.
Now he stated that he would release the unredacted statements. I personally read them, and it seems to me that there were a lot of things that were left out and redacted. Now, July 5th, 2024, Kayla Bumpus, who was one of Kenneth Copeland's attorneys at the time, that stood in for the original attorney, John Melnick, went live and kind of spoke on the case, and Kenneth Copeland joined the live. To sum it up, I was right. Chief Judge Ural Glanville didn't release the full unredacted statement.
You just missed Melnick.
I'll watch it.
Oh, okay. Woody, is the transcript complete? You say no?
You know that.
So guys, I just want to say that even though Woody fired me, as you all know, I still have to protect his interests. And I want to say we will not be talking about the case. He cannot answer anything. As you guys have seen over and over again, the state is watching. I'm sure they're on. Say hi to the state, everybody, because we know they're watching. So we got to protect Woody. We don't want anything to come of this. But what questions do you have for Woody? Did you fire me for real? Have they released you, or do you still have to go back?
They better release me.
Have they released you, or did they say they may call to ask you some more questions? No, nothing. Huh? Do you have anything you want to say to everybody? No.
You all right?
I'm okay. All right, everybody say thank you for joining us to Woody.
Yeah, because I don't know what I'm doing on here, so I
Well, you're doing a good job. Everybody, drop a green heart for Woody. Let's see green hearts. Come on, let me get some green hearts.
not no green heart. You know how these people play. Put a white heart
I
on.
love green. That's my favorite color. I've been making.
Yeah, I love green too, but
Okay,
people,
let's drop pink hearts for Woody.
yeah, pink will do it.
Okay, let's do pink hearts. Come on, let's get some pink hearts. Woody, have you?
Everything we do is you know how they do it. You know
You
what's
know.
going on.
Look, Woody. So, do you think that all these? How you feel about all these memes on the internet? Do you think they're funny?
No, these people see me out in.
We lost them. Let's see if we get them back, guys.
To sum it up, I was right. Chief Judge Earl Glanville didn't release the whole unredacted statement. What are your thoughts so far? Is it me? Or did you hear Kenneth Copeland plead the fifth twice under oath? How many times did Kenneth Copeland say he was pleading the fifth before the judge sworn him in? Do you believe they released the full transcript of the secret ex parte meeting? Do you think the Georgia justice system is corrupted? Leave us a comment. Don't forget to hit the like button and subscribe to the channel for more content like this.